H1B application process and related terminology. Employer sponsorship. An employer in the United States sponsors a foreign worker for an H1B visa, usually for a specialized job requiring a bachelor's degree or higher. Labor Condition Application, QA. The employer files an QA with the Department of Labor, DOL, attesting to compliance with wage and working condition requirements. Form I-129 Petition. The employer submits Form I-129, along with supporting documents, to U.S. Citizenship and Immigration Services, USCIS, to petition for the H-1B visa on behalf of the foreign worker. Cap subject or cap exempt. If the H-1B visa is subject to the annual numerical cap, the employer participates in the H-1B lottery for a chance to secure one of the limited visas. Approval notice. If selected in the lottery and approved by USCIS, the employer receives an H-1B approval notice, allowing the foreign worker to begin or continue working in the U.S. Consular processing. If the foreign worker is outside the U.S., they must apply for an H-1B visa at a U.S. embassy or consulate through consular processing. Visa interview. The foreign worker attends a visa interview, providing required documents, demonstrating eligibility, and answering questions related to the H-1B employment. Travel and entry. Once the H-1B visa is issued, the foreign worker can travel to the U.S. and present the visa to immigration officials at the port of entry for admission. Change of status, if applicable, if the foreign worker is already in the U.S. under a different visa status, they can apply for a change of status to H-1B without leaving the country. Employment and visa extension. The H-1B visa allows the foreign worker to work for the sponsoring employer for the approved period, typically up to 3 years, with the possibility of extensions. H-1B transfer. If the foreign worker is already in the U.S. on an H-1B visa, they can transfer their sponsorship to a new employer by filing an H-1B transfer petition. Prevailing wage determination. Before filing the H-1B petition, the employer must obtain a prevailing wage determination from the DOL. Public access file. The employer must maintain a public access file containing required documents related to the H-1B employment, including OCA, wage information, and notice postings. USCIS processing time. The processing time for H-1B petitions can vary, ranging from several months to over a year, depending on the workload and USCIS processing times. Premium processing. Employers can opt for premium processing, by paying an additional fee, to expedite the H-1B petition processing time to 15 calendar days. Dependents. H-1B visa holders can bring their spouse and unmarried children under 21 years old to the U.S. on H-4 dependent visas, allowing them to accompany the H-1B worker. H-1B cap exemptions. Certain employers and positions are exempt from the annual H-1B numerical cap, such as universities, nonprofit research institutions, and government organizations. H-1B portability. H-1B visa holders who have an approved H-1B petition or pending extension can change employers and start working for the new employer upon filing the new H-1B petition. H-1B visa extensions. Employers can file for H-1B extensions to allow foreign workers to continue working beyond the initial approved period, typically in 3-year increments. Green card sponsorship. H1B visa holders may be eligible for employer-sponsored green card sponsorship, allowing them to pursue permanent residency in the United States. Contact Goal Abroad Consultancy +91 -93925833054, info@Goal Abroad for more updates and services.